Fine, thank you. It's been a really amazing month, I think, since we were all at the last beta, and I think everybody was probably expecting the blockchain to launch and it's been flawless and smooth going. It's been, of course, quite a turbulent first 3 or 4 weeks. One of the big things that everybody has been expecting was a governed blockchain. It's a phrase that we've heard a lot that's been talked about. Arbitration is another key aspect of that. And what we've actually seen, of course, is some really controversial decisions that block producers have had to make regarding freezing of contracts. We've seen a lot of criticism from across the world around those decisions and the way that they're being implemented. And then just to further add some interest to all of this, of course, we've seen other constitutional versions starting to be proposed as well. This is all, I think, part of what we should realistically expect with a brand new blockchain. We're seeing a new economic ecosystem that's starting to be built out, and I think that's something that really we need to be a little realistic about. We're starting to work through some of the problems. The round market is another one of the existing costs right now that we're seeing, and we're seeing a lot of discussion in the community on that. But with regards to arbitration itself, we have an interim constitution right now. We have as well an interim arbitrator that was named in that constitution, which is ECAF, which is the EOS Core Arbitration Forum. And tonight we have Moti Tabulo, who is the head of ECAF, and he's going to give a speech and tell us more about that.
Thank you. Okay, hi everyone. So I'm Moti. Show of hands, who has heard of ECAF before today? Okay, and keep your hands up if you heard of it from a CoinDesk article. We're going to have an interesting time today. Okay, so as David mentioned, I'm the interim administrator for ECAF. Okay, and my role within ECAF is really to put in place the structures for the organization. So put in place the support, raise money, and essentially get the whole ECAF organization up and running. I would say that I'm not a lawyer, okay? So don't hold that against me, all right? And yeah, so there, well, we have the danger of doing your slides in a different format. I hope you can read it, but I'll talk in case you can't. So ECAF stands for the EOS Core Arbitration Forum. Now, when we were naming it, we thought that, well, we would have a nice little acronym that, if you spell it backwards, spells face, okay? And we thought, well, it would be the nice human face of EOS. Little did we know. So, in this talk, I'll be talking about what is arbitration and why we need it. I'll talk about the ECAF structure, how it's set up, and how we bootstrapped it into the launch in mainnet. And then I'll also talk a little bit about what's next. What's next for ECAF, what we have coming up. Talk a little bit about some of the options that we see, either going with the current constitution or with some of the other proposed constitutions. So, why arbitration? Well, right here, we are 4 weeks from launch. You know, everybody's super excited. There's this new technology that's out there, and we're looking to develop all kinds of new businesses, distributed applications, etc. The possibilities are limitless. So, we're going to the moon. But what happens if we hit a rocky road? Okay, if we hit a bump on the road, we've developed our dApps, everybody's using them, but then we have an issue, right, between our dApps and the users. How are we going to resolve that issue? Well, you might say that we have a contract, don't we? And it might even be a smart contract that describes what will happen when we have an issue, how we're going to resolve it, etc. Yeah, and you would be right, probably. You'd be wise to put in a contract between you and other dApps, between you and your users. So, when you develop in your dApp, I'm sure all of you, the first thing that you do, he says, is sit down with your lawyer, think about all the different possible situations that could occur and how your DAP is being used, and think about how you could have elements in your contract that would counteract those clauses. Well, some people might do that, but I think most of us are more interested in the business side and making something that's of value. So we end up writing a contract, we think of some situations that may occur, and, well, we make a few lawyers a little bit richer because they have to draft our big contracts with all of our clauses. But there's an issue with that, in that we can't actually draft a contract that considers all possible eventualities, right? Because to do that, you'd have to predict the future. And we know that, well, typically humans are bad at predicting the future. That's why I'm here, instead of being out there buying lottery tickets and making shed loads of money, right? So contracts can't cover every eventuality. And economists have a term for this. They call these incomplete contracts. So an incomplete contract is a contract that doesn't cover every single eventuality, right? Because the future is unpredictable. And it's even more so in a business like the blockchain, where it's a completely new business. We don't know how the business will change, how our dApps will change over the next 10 years. So thinking that we can have a contract that covers all possible possibilities from the outset is probably futile. So your dApp is working, you've deployed it, people are using it, and then you have an issue, right? And because you have an incomplete contract, that means that there's a situation that may occur that is open for interpretation. And then when you have things that are open for interpretation, you have opinions, and you have different parties with different opinions. And when you have different opinions, you have disputes. So a dispute arises. And that will happen because contracts are incomplete. So how do we resolve these disputes? Well, in the real world, the off-blockchain world, one way we could do that is by going to our local courts, right? So I would go to the magistrate, say I have a dispute with so-and-so, he broke the terms of my contract, or we don't agree on the terms of the contract, and I'd file a case, that would be heard, etc. Okay? So that's one path that we can follow. But we're operating in a blockchain world, okay? So we're operating in a global context from the outset. I mean, probably your dApp counterparties will not be from the same jurisdiction as you. They'll not be from the same state. And most likely, nearly most of your users will not be resident in your headquarters. So, and then the other thing is that blockchain brings a new context. So before you even get a judge to look at your case, you've got to go and educate that judge. You've got to go and educate your lawyers on what is a blockchain, what is consensus, what is immutability, and what is this dApp thing that you keep talking about, right? Even before they can actually start looking at the meat of your case and what is how to resolve it. So all of that ends up adding to inefficiencies, right? It's inefficient for businesses because they don't have a common framework. Yeah, they don't know whether if they have a dispute, whether that dispute is going to be heard in this country or another country, or a country where they don't know the rules. And that inefficiency is a barrier to conducting good business. So let's look at an example. So, for example, if we had, let's say, a German dApp, I just choose Germany for whatever reason, and another dApp, let's say, headquartered in Bermuda. So if there's an issue between the two dApps, the German dApp maybe has an issue that the Bermudian dApp didn't fulfill. Now the German dApp files a court case in Germany. So all of a sudden, the guy in Bermuda needs to hire a German lawyer, needs to understand the German context. He probably also needs to go and attend cases in Germany, right? From Bermuda, and we're talking in the Caribbean, right? To Germany. So this is a big impediment to running, to resolving a dispute. So courts are one way. There's another way. That's arbitration. So with arbitration, typically you would have in your contract, you would insert an arbitration clause, which says that any disputes would be heard in an arbitration forum. And I'll come to what a forum is in later slides. Right? So you have disputes being heard in an arbitration forum. What advantages does that give us? Well, because we have one context, we have agreed beforehand that there is a context for how we're going to resolve those disputes. Right? So we both understand that there's a certain rule set and there's one place that we can both go to resolve those disputes. So contrast that with the case where you're interacting with users from across the world, with dApps from across the world, and you're worried that you could have any one of those users file a claim in their local court. So you could potentially have a case in whatever it is, 190 countries across the globe. But with arbitration, you have one place, one rule set where you can go and you can have, and you know the rules beforehand. So everybody has the same common operating ground to resolve a dispute. So, and another advantage you can have is, well, you could decide to choose an arbitration forum that gets this blockchain thing, right? That understands what is blockchain, understands the context, and is able to resolve your dispute further, faster, because they don't have to spend time understanding, what a blockchain does. So all of that means that it reduces friction, right? It reduces friction to doing business because it gives businesses certainty about how they're going to resolve disputes. Okay. And that's why arbitration is so important. I mean, if we leave aside blockchain for the moment and we just look at general business, for commercial business, dispute resolution, arbitration generally is the most preferred way of doing that for similar reasons. I mean, if you look at, for example, if you're doing maritime law or maritime disputes, there's a maritime arbitration forum that you can go to. They understand all the context about ships. If you're, and there's different arbitration forums that focus on specific areas of business. Okay. So arbitration isn't new, right? Back when we were all living in small villages, if we had a dispute, would probably end up going to our elders and they would resolve the dispute for us. This is a picture of the governors of the wine guild from 1663 or something. Portrait, we didn't have pictures. A portrait of the governors of the wine guild. And wine guilds in those times, one of the functions they did was also resolving disputes between their members. So if a guild member had a dispute with another guild member, they would go to the governors, and the governors would help them resolve that dispute. So yeah, arbitration is not new. What we are trying to do with ECAF is do arbitration in a blockchain context. Okay. So, EOS and arbitration, how does it all fit? So we've got this concept of a governed blockchain, right? And a governed blockchain has three pillars, as we think of it. The first is the token holders, right? So that if you think of it as a republic almost, not that we are creating a republic, but it's a helpful analogy. A republic has a legislature, which are the token holders, and they would vote on issues that are of importance for the whole community. So this could be on the constitution that sets out the rules of this governed system. This could be perhaps on critical features that require the consent of the whole community, right? And they would vote by doing referenda. Then the next thing we have is the block producers. So they are the executive. They execute the code, they produce blocks, and they also carry out judicial decisions. And the third pillar is the arbitrators. So they form the judiciary, right? So they resolve disputes and make special decisions. For example, making a decision on whether the constitution needs amendment. They could recommend that as an example, right? Apart from also resolving disputes. Okay. So with all of these, we get the concept of a governed blockchain, right? Now, ECAF. How does ECAF fit into it? How is it structured, etc.? So, to create an arbitration forum, what you first need to do is to have its basis for existence. In ECAF's case, that is by being incorporated in the EOS constitution and also having a rule set for how it's going to be able to resolve disputes. Okay. So this gives its basis for existence. And then we have the people that will make decisions and will run the forum. So these would be the arbitrators first. These are individuals who rule on disputes in their own name. Okay. Then we have case managers who assist the arbitrators. They may do things like reviewing cases, filtering the cases, and also collecting evidence from claimants and disputants, checking that cases are complete, etc. And finally, we have support functions. So support functions could be technical experts, could be lawyers, whereas specific to areas of law, blockchain, smart contract experts, etc. And finally, and administrators. So when we set up ECAF, we faced the chicken and egg problem. ECAF is intended to be a self-governing body for the community and authorized by the community. But we wanted ECAF in place at launch in order to be able to rule on disputes that block producers may have or that users may have with block producers or other users. Right? So we had this situation where we needed to get a dispute resolution service in place ready for launch, but at the same time, we couldn't get a referendum running because there was no chain available to run a referendum. So we had to do something to bootstrap this process. And what we did is similar to what your computer does with its BIOS. Now, with a BIOS, you have a basic operating system, a very little one, that does some minimal set of functions. It boots up, and then it goes off and runs the bigger operating system, the main operating system. And so we've followed a similar approach with ECAF, where we have an interim arbitration forum. So that's ECAF as it is constituted now, an interim arbitration forum at launch, ready to rule on disputes, and forming the seed of a future fully ratified arbitration forum. Okay. So with this interim arbitration forum, we have the basic rules in place. We have a set of interim arbitrators named, right? And the intention is that once we have a referendum contract available, fully tested and working, that we'd put the ECAF to a referendum. So a vote by token holders to either ratify the ECAF or put us out of a job, right? So yeah, so then the community would vote and they could propose a different forum or they could propose a different makeup at the time of the referendum. Yeah. Now, something also to note is that even though ECAF is, let's say, in the current constitution, the default forum, there's still the possibility, app developers always have the possibility to override ECAF by naming a different arbitration forum within their smart contracts. So you could sit down, write your smart contract today. You don't like the ECAF for whatever reason, you could name the London Court of International Arbitration as your preferred forum. You could name the International Court of Dispute Resolution in the US. You could name the Maritime Arbitration Forum if you wanted to. I mean, maybe you're shipping, and you think that's better for you, right? So you always have that option, regardless of what is in the Constitution. Developers always have the option of naming an alternate forum in their contracts. So where are we right now? We've launched. We have an interim arbitration forum, ECAF, and we've got arbitrators named, right? And they are undergoing some training. We have started to hear cases, and we also have some big process improvements, right? We do recognize that, and it's part of any new system. There will be improvements that need to be made to its operation. But yes, we're hearing claims that have been filed and going through the process. Right? So that's where ECAF is now. What's next? So right now we have the current constitution, which names the ECAF as a default forum. There's been a new proposed constitution, which institutes the idea of multiple parallel forums and no default forum. Right? So that's one alternate future that we have. We also have in these constitutions a difference in the law. Say there's one is the current constitution is like the law is the law effectively. The proposed constitution has the intent of code is law, right? That's an alternate option. And really effectively it will be up to the token holders at the time of a referendum to decide which constitution to choose, right? They may decide to choose the proposed one. They may decide to choose somebody may propose something that's in between the current and the proposed, and yeah. And well, we'll see when that referendum comes out, the structure of that referendum, what options people will be given. However, what we see is that whichever way it goes, ECAF can still continue offering arbitration services, right? So in one future, ECAF remains as the default forum, as it's currently constituted. It continues hearing cases where people did not name an alternate forum for dispute resolution, or where for some reason the arbitration forum that they chose denies jurisdiction, so it denies to accept their case, then ECAF is the fallback. In another future, where ECAF is one of many parallel forums, then ECAF still continues offering dispute resolution services, right, as one of the many parallel forums, right, and still continues offering arbitration services for the EOS blockchain. In that future, ECAF is, let's say, an expert in EOS arbitration. So what we want to do is continue with improving communications with BPs and the community, recruiting additional arbitrators, case managers, especially from the non-English speaking community, improving our software infrastructure and processes. So that brings me to the end of my talk. Hopefully I've given you a sense of why we need arbitration, why we, how we bootstrapped ECAF, its current structure, and possibly an indication of how we go ahead in different futures. Any questions? So I think you in the gray shirt had your, do you have mics?
Yeah, so.
Cool.
So I'll come around this microphone, 50 people. They can ask questions. You can all hear them. Cheers. Yeah, Alex Maltz here. Nice presentation, by the way.
Thank you.
I'm a little bit confused because you did say decentralization, right? But what I see you proposing here is just you're appointing some people and you're just moving power towards them, and that's not decentralized. So I just don't understand where decentralization comes from. And actually, the real question is like, what if people decide to collide the arbitrators or even on the EOS network because they're using delegated proof of work? So what happens in those worst case scenarios? Thank you.
Sorry, could you repeat the last bit of the question?
So I said,
what if
arbitrators decide to collide, right? And what if people collide even on the EOS network because they're using delegated proof of stake, which means I have stake, you have stake, you meet together. It's like, why don't we put our stake together to, is this something we want?
Oh, so you mean collude, right? Not
collude. Sorry.
Yeah. Okay. Right.
I'm an immigrant. Sorry about that.
No, that's fine. I was just getting the question. Yeah. So in terms of collusion, there are checks and balances within the arbitration process. So when an arbitrator makes a ruling, they have to provide the legal basis for their ruling, and that ruling is published, and people can review that. Right? So if an arbitrator is consistently ruling in favor of some party, that will become obvious, right? And that opens up a challenge. That opens up an opportunity for people to challenge that arbitrator. First, they open the arbitrator's rulings, and thereafter it opens them up to challenge the arbitrator themselves. Right? And so an arbitrator's appointment can be revoked if they're found to be colluding, to be biased. Yeah.
That's like a double. You wrote back. You just wrote back time. Extended conversations / arguments. I'm sure that we could start it if done the bar afterwards.
Okay, so yeah, we can continue afterwards. Yeah. Yep, be in the back there. Yes.
I just wanted to know what kind of cases will ECAF hear and which cases will you not hear? is there anything that comes to you that you just want to take part in or you need to take? And what cases will you arbitrate on? Is there any particular type of case you tend to do that some that you want to take?
Well, I think the easiest cases are where both parties have explicitly said that they accept the ECAF as their dispute resolution forum. Those are the easiest cases because then there's clear jurisdiction. It's clear that ECAF is the forum that they should use. I mean, in terms of cases that we wouldn't take, yeah, I would have to think about that. Probably something. Well, yeah, I'd have to think about that.
Hi. So I had a question. Right now, there's been a lot of objections around the EOS system that the block producers for the arbitrators would just basically reverse everything, which in some ways reverse the transaction, which goes against many of the things that people believe in about blockchain with immutability and decentralization. What about the possibility of people being able to opt in to say a particular account is completely locked and completely immune from arbitration or block producers, like as immutable as you would have on Bitcoin, for example, or something like that?
Okay, so just as a clarification, when people say that arbitration means you're rolling back transactions, I mean, I hope we all understand that we're not actually modifying the blockchain. When an arbitrator makes a ruling, they propose a new transaction, which could have the effect of negating a previous transaction, but it's not going back and changing the chain. The chain is still immutable, but the transaction is modified, is changed. Right. So yes. So in the new constitutional proposal, there is that alternate future where you don't have a default forum and arbitration is an opt-in service, right? And that is one future.
We've got two more questions. This guy.
Well, guy in the hat had his hand up for ages.
Okay.
Sorry.
All right. Thanks for that. So going on his example from the before, what happens if we have an arbitrator who becomes corrupt? Could you walk us through an example of how we make that person accountable? What are the democratic processes that are in place to remove them from quote-unquote office?
Yeah. So if an arbitrator becomes corrupt, then basically a disputant or a claimant in one of their cases, or even a community member could say, well, this person is corrupt, and they would file a case with the forum, right? And then you'd have a set of, let's say, a review panel of 3 arbitrators appointed, who would then look through your evidence that has been put forward around whether or not that arbitrator is corrupt. At that point, then the arbitrator, if found to be corrupt, will have their nomination revoked. They'll be off the forum. And then effectively it opens up their rulings that they've made that were potentially corrupt rulings. It opens those up for re-examination. And it's a key point because arbitrators rule in their name. If they rule correctly, without bias, without collusion, they have immunity from liability. If they collude, then they are liable to the effects of their rulings. So it's actually putting arbitrators in a big personal hazard by being corrupt.
Thank you very much. It's a pretty basic question, but I'm pretty ignorant. When you refer to the referendum, how do the votes work? Is it the number of EOS that you have as a Genesis snapshot, or isn't there a case to make the number that you have not irrelevant, but the higher blocks, if you like, have less power than the actual numbers of EOS they hold?
So I think it's based on the number of EOS in their account. So you could have bought more since the launch, but it's basically based on the number of EOS in their account. But if you follow the governance channel, there's a lot of people who propose different voting schemes, but we use essentially proof of your stake as your voting. Well, your stake counts for voting.
Okay, so that's just for the cryptocurrency. it's a problem which can affect the value of the So can you, as the arbitrator, and we know we can't reverse a transaction blockchain, so we can create new transactions. So that's the arbitrator. If I have $1 million worth of EOS stolen from me, can you help me recover my EOS? If I want EOS stolen.
Yeah, good question, which forms the nexus of the claims that we've been hearing so far. So yes, the intention is that as currently constituted, the arbitrators could find that your tokens were illegally taken from you and could have a ruling that if the token still existed, to have those restituted to you, right? If they still well not existed, but if they can still be found, they haven't been washed through an exchange, etc., then they could make a ruling that those tokens be retransferred back to you.
Right, so basically we have two companies, one in the States, one in Germany, and we use your services, we go for arbitration, and like my company doesn't get the outcome I wanted, I didn't win. What stops me from using, like, taking me to court back again in the States or in Germany?
Sure. So you can do that, but I think what is I think there are over 140 countries around the world that have accepted arbitration as binding, right? So arbitration decisions as binding. So if you had an arbitration case, a ruling was delivered, then you went to your U.S. court and said, well, I don't like that ruling. The U.S. court would look at the fact that you've gone through arbitration, and they would see the ruling. And generally speaking, they would uphold that ruling, right? Unless you could point to some deficiency in that ruling that the arbitrators made. And as I say, this is across over 140 countries who have accepted the principle of arbitration as being binding. Most of the important, well, not important, but commercially active countries.
Hi, Arnie. I just wanted to know what your thoughts were on the cost of arbitration you talked about. How do you foresee the supply and demand models for the cost of it, and maybe any potential issues that arise from there being huge demand in arbitration, which can sometimes have an impact on maybe those who can't afford arbitration?
Yeah.
This seems to me to be an outlying big issue.
Yeah. So actually, when we're constituting the ECAF, as I said, we were looking at doing arbitration for the community. And effectively, what we want to have is arbitration that's affordable for the community, right? So, like right now, if you wanted to file a case with the ICDR, the International Center for Dispute Resolution, just to file a case is $5,000 US, right? That's a pretty high barrier to entry, right? So, and we want, at least with ECAF, we want that barrier to be set at a achievable standard, right? Now there's going to be discussions as to what is that entry, but we want to make sure that people can afford, the community can afford to have arbitration as a recourse. But to your point about the market, I mean, yeah, there will be an open market. Just because ECAF, if in one future, is the default forum, just because ECAF is the default forum doesn't stop other people naming other arbitration forums. And those arbitration forums might, let's say, specialize in certain areas. And because they specialize, they might warrant charging more for it, yeah? And that would be the market.
Hi, just a simple EOS token holder. My question to you is, I'm struggling to understand the benefits of ECAF at a protocol level as to having ECAF at more at that level. What do you think?
Yeah, so this goes to let's say, probably the crux of the different constitutional proposals, where probably the current constitution is at a protocol level, whereas the proposed constitution is at a DAP level, right? So, well, one thing with the DAP level arbitration, I mean, I still need to fully understand how that works. I mean, there's different structures within that have been proposed. But one issue with the DAP level arbitration is you may name a forum between you and other DAPs, or potentially, or maybe you and some of your users. But what if you interact with a DApp that you don't have a contract with, right? Then who resolves that dispute, right? Or are you, one of your users or whatever is affected, somebody using your DApp is not covered by a contract, well, who would then would resolve that dispute?
Levels resolving issues in the speedy ways on the network, generally just given a consensus to everybody that there's issues outstanding. Wouldn't it be better to have at that level a resolution recourse?
Well, I mean, even when you say protocol level, that doesn't necessarily mean that you're holding up the whole network, right? Because it could be an issue, even though it's the arbitration forum is defined as at the base level, the issue might be in a particular operation of that DApp. So you don't have to necessarily stop the whole DApp. You could stop a portion of the DApp, right, if it's structured in that way, and resolve that dispute that's related to a portion of that DApp. So there's, yeah. I don't think there's a black and white answer as to which one is better than the other. Yeah.
Thank you very much for both your talk and your answers, Moti.
Thank you.